This is what I'm going to be covering in the next half an hour or so before I hand you back to William. Firstly, the legal bit, i.e. the law of loss of a chance. And this is really just to make sure that we understand the history and the basic framework of the law which applies where the claimant has lost a chance of a pecuniary benefit for our purposes, that pecuniary benefit being a potentially very lucrative career in sport. Then the anatomy of a claim. Which head of loss might you need to think about in such a claim? What is your schedule of loss or your counter schedule going to look like? And then experts. Which experts can give evidence? Which evidence will they be able to give and why do you need them? Focusing primarily on the recent case of Swansea City and Owen, which was an appeal from a case management decision of Master Eastman about which experts the party should have permission for in a claim arising from loss of a footballing career. I'll then run through some examples of loss of sports careers that have gone to trial over quantum in the recent years. Langford and Hebron in 2001 was a case about a road traffic accident which caused the loss of the claimant's kickboxing career. And then the second case on the slide there is Appleton and El Safdie, which is a footballing case arising from a goalkeeper who played for West Bromwich Albion and his injury. And then last but not least, Collett and Smith in 2008, which is an appeal against a first instance ruling that Mr. Collett should recover £4.5 million for the loss of his promising career as a professional footballer. Finally, looking at these examples and sports claims in the round, we've sought to distill some general guiding principles from the case law, and we've also put together a checklist of issues for preparing or indeed defending such claims, i.e. what the evidence needs to cover, relevant factors to consider.